Chapter 7 Bankruptcy. When you hear people talking about filing bankruptcy, odds are they're talking about Chapter 7. It's the simplest and most common form of bankruptcy. If you file Chapter 7 bankruptcy and have assets not protected by an exemption, the trustee might sell those assets and distribute the proceeds to the creditors. Creditors will be prioritized based on the rules set out in the bankruptcy code. In most cases, you'll get a discharge of your personal liability for most debts, which means you no longer have to pay them back. Almost 99% of Chapter 7 bankruptcy cases are discharged without the trustee selling any of the debtor's assets. Am I eligible to file Chapter 7? Your eligibility to file Chapter 7 bankruptcy is determined by the means test, which was introduced in 2005 when the Bankruptcy Code was amended. High earners with primarily consumer debts might not qualify for Chapter 7. However, if you enlist the help of an experienced bankruptcy attorney, you'll likely be able to file. Chapter 7 is generally the quickest and least complicated form of bankruptcy. It's available to individuals, married couples, corporations, and partnerships. How do I get started? Your bankruptcy case is initiated by filing the official petition, schedules, and statement of financial affairs. These forms ask you to list all your assets, like your cars, boats, houses, all your debts, like your car loan, your credit cards. The court will also ask you some questions about your financial history, what you've spent money on the months leading up to the bankruptcy. It's essential to make sure the correct mailing addresses are listed for every creditor, that all your debts are listed, even if they're non-dischargeable, like student loans. The schedules will also list your property, things you own in addition to real estate, any debts that you use as property as collateral, how much money you'd expect to get if you sold the property. You'll have an opportunity to list any exemptions. Since you'll be signing these schedules under the penalty of perjury, it's important to make sure they are accurate, as you can make them. If the court decides the information in the schedule is deliberately false or inaccurate, they can deny you a discharge of your debts. Your attorney will submit this paperwork to the bankruptcy clerk in the district where you've lived for most of the last 6 months. Your rights and those of your creditors are those that exist on the day your case is filed. Everything about your case after the filing will relate to the situation as it was on that day, as if there was a freeze frame at that time. The moment your petition is filed, an automatic stay goes into effect. The stay is a court order that stops your creditors from initiating, continuing, collecting on any debt. The court will appoint a trustee, send a notice to all the creditors listed on your schedules that you file bankruptcy. You will also receive a copy of that notice.